Legal malpractice and divorce in Massachusetts. Hi, I'm attorney Neil Burns, and we're going to talk today a little bit about divorce in the context of legal malpractice in Massachusetts. I've been practicing legal malpractice law for over 30 years here, and we get a lot of calls from people who are dissatisfied, disgruntled, unhappy with their lawyer after a divorce. Most of the time, there's not much we can do. The pie is only so big and has to be divided 50-50, 60-40, however it gets divided. But frequently, what we have found is there's a huge problem with the process the attorney took towards getting the divorce for the client. I'm going to give three basic examples, and these themes happen over and over again. Number one is there's a house, and the lawyer has failed to get a proper evaluation of the house or a rental property. And they go to a meeting, a four-way meeting or a trial, and the client finds out that the other side has an evaluation, the other side has an expert, but we've got nothing. And the values are very vastly different, but they're in a position of weakness. Another example is the same thing, essentially. One of the parties owns a business or has an estate that they're going to inherit, but the lawyer didn't prepare for this. The lawyer didn't get an expert to evaluate the business. The lawyer didn't subpoena the records from the estate or the trust. We have no idea. The client has no idea, can present no evidence whatsoever to the judge about the value of this important asset. And yet, there's a trial date and the judge is saying, come on in for trial. Again, negotiating from a position of weakness, you'll lose. And the third general situation is just a general position of weakness. You go in for the trial date and the lawyer isn't prepared, doesn't have the documents, doesn't know the case, sends an associate, and position of weakness. Either you settle from a position of weakness or you try it in front of a judge and the other side is completely prepared, has their witnesses, has their documents, has their evaluations, and you're not. If you've been in one of those situations, you may have a case for legal malpractice and divorce. Be careful. You have to relive the divorce. You have to prove everything that would have been proved in the first case. But if you've got a good case, if there's an asset there that wasn't valued, or a trust that wasn't valued, or a business, or a house, you may have a very good case against your former attorney for legal malpractice and divorce. If you think you have a case, give us a call. We've been doing this for over 30 years, Burns and Jam. Give us a chance. We get incredible results when there's a case. Thank you.